Hey everyone, Harry here to talk to you about metadata, namely the metadata that still remained in the Supreme Court opinion in the Colorado insurrection case that was clearly rushed to market on Monday, the day before Super Tuesday, because the court wanted to get it out quite clearly before the primary, so people in Colorado, maybe around the country, knew that Trump would, in fact, be on the ballot. I'll just make this point that I made in an op-ed yesterday, but not in our immediate YouTube, which is they sure showed sensitivity to timing and wanting voters to have full information about Trump before going to the polls. You would think that mindset would translate into wanting to voters to have before November the knowledge of whether Trump's going to be an adjudicated, or at least a jury finding that he's a felon. But the timing that they've put out in the immunity case is not nearly as sort of warp speed. It's not slow, but it's much slower than other real instances of really going quickly, and even slower than the Colorado case. So that's an aside, but they certainly were going lickety split to get this out, and that's why you had this little problem. There's almost sort of charm to it. The Supreme Court's kind of a small place. And there's not many layers of review, and it'll go to a reporter of decisions that look at it. But anyway, they rushed this out, and keen observers, including Mark Joseph Stern and Slate, could see up top that Sotomayor. We talked about this yesterday. An opinion for the court, then an opinion for the three justices, Kagan, Sotomayor, and Jackson, styled a concurrence, and then likewise one for Barrett that was a concurrence. But it looks as if the Sotomayor opinion began, the one for the three of them, began its life as a concurring in part and dissenting in part, and it sure reads that way. I talked about this also in the op-ed. The basic kind of quick summary here is the court and Chief Justice Roberts gets his unanimous holding and gets to say in the last paragraph, we all agree that Colorado violated the Constitution, but a half inch below the surface is some very strong disagreement with what the court has done. Even Justice Barrett, who does not join the other three and is sort of pointedly more diplomatic, saying, this is not the moment to combine disagreement with stridency. The American people need to be reassured. Even she takes is pretty strongly takes the majority to task. And here's why. We talked about this from the start with this issue. On the one hand, it seemed like, how could the court do this? That was always my feeling, and that did prevail, and that was accurate from the start. On the other, if you look at it, it's textually, historically, equitably, it sure seems like it was a fit to what Donald Trump had done. And the question was, what rationale will they choose, and how will they do the least harm? One way they could have done the most harm, they couldn't have done this by the time they took it, but this is something that some advocates feared, is if they would somehow give Trump a clean bill of health and say he wasn't an insurrectionist. They did not do that. But there were other concerns about basically really weakening the provision in Section 3 of the 14th Amendment that says if you swear an oath and then you basically betray your country, engage in insurrection, you've forfeited your right for future service. And the five of them may really cut the legs out from under that provision, at least more than they needed to, because they said they went ahead and said a state can't do this because it would have a kind of, and this was the exact words I used after our argument, a patchwork pattern, and that's chaotic, and nothing in the Constitution makes us requires us to endorse such a result. And says the per curiam majority, the per curiam, but 5 justices in it, and that's enough to decide the case. But they then go on and say basically Congress has to enact legislation. That's what has to happen to effectuate. They actually have to have what, maybe an individual legislation that says you know this particular official committed insurrection. That itself could have constitutional issues, or defining things in general, as they've done, say, with the insurrection criminal statute that does provide for disqualification going forward. But that's a real limitation on, and in fact, it's ahistorical. It doesn't show up in the opinion, but the last time that the Congress actually employed Section 3 was just in a straight vote, refusing to seat a socialist named Berger, who Wisconsin voted in just after World War I, and Congress used that provision to send him back home, and then they sent him again. They sent him back home again, and then finally they sent him again, and it stayed that way. But it is a counterpoint to the notion that Congress has to pass a statute, right? The House votes. They get over a filibuster for debate that which might require having 60 votes. The House votes. The Senate votes. The probably the president, if depending on what they mean by legislation, signs it into law. That's a tall order, and moreover, it's so inherently political. We've seen this in the impeachment setting now, where it doesn't matter how strong the merits are if you don't have sufficient numbers in the House of your party. You're not going to convict a president, and it does seem as if they've similarly weakened Section 3, and they may have had a specific Trump assist in mind, because if they had said it's just up to Congress, that's it, it's up to Congress. Now, let's say Trump wins in November, but we're in the period between November and January. But let's also say that the Democrats retake the House. At that point, if it's just a matter of a vote or whatever by the houses, they could vote. I think this might have been the Supreme Court's mind, and say, we're not seating Donald Trump. We're not going to let him be president. We are exercising our rights under Section 3, and saying he's disqualified for all time. And that, now, of course, that would be bedlam, chaos, crisis, etc. But it would be a lesser step of saying Congress has the power here, not the states. And they took the greater step of saying, Congress needs to pass legislation. So Barrett takes them to task. You went too far. And then the 3, and now back to the metadata point. So there's a reason to think this is all now, tea leaves and Kremlinology and putting together. It's almost like trying to reassemble a shredded document. But at oral argument, Sotomayor definitely seemed the one least amenable to kind of going along. Both Kagan and Jackson were clearly looking for ways to find that Colorado had to reverse Colorado, but without totally eviscerating Section 3. Seems possible, and Mark Joseph Stern's article kind of lays out I'll just say a plausible scenario. It's a black box sometimes, or often, the Supreme Court, so you can't say, but it's consistent with what we've seen, and with this tantalizing detail of the metadata, and at first having been a dissent by Sotomayor. We don't think that Kagan and Jackson were looking to dissent, but it might be that Sotomayor sort of drafts a dissent, and that Kagan and Jackson are trying to assemble a coalition of 5, Barrett would be the 4th, to not go too far here, to not, to say Colorado wasn't permitted under the Constitution to do this. It doesn't go to the states, and then stopping. And so the obvious suspects here might have been either Chief Justice Roberts or Brett Kavanaugh, but they could have really sort of withheld their votes and tried hard to cobble together 5, and it's just one vote, right? So but for that, one vote, we'd have a very different legal landscape today on Section 3, where we wouldn't be saying you need congressional legislation. So it may well be that they tried, they couldn't do it, and at that point they retreated to join the Sotomayor opinion, which had begun its life as a dissent, but they didn't want to or as a concurrence in part, dissent in part, but they didn't want to be doing a dissent. They wanted to, definitely reverse Colorado, and so in joining. And I'm sure Sotomayor was more than happy to do this rather than be the single outlying justice. They convert the opinion to from a dissent in part to a full-on concurrence. There's additional kind of almost detective work about certain phrases that seem more like they'd come from Sotomayor's pen than otherwise, based on her style of writing, and that reinforced the notion this was hers and she drafted it as a partial dissent. And Kagan and Jackson, withheld their vote, tried. Man, what a tough effort up there to get any little concession on the left. And it would have been a pretty big, wresting victory from the jaws of defeat, or at least a pretty big event, had they 5-4 gotten Barrett and either Roberts or Kavanaugh to endorse a much narrower rationale, but it wasn't to be. And so, just underneath this supposed this actual unanimous decision for the result are pretty strong fault lines, and the familiar ones. Interesting about Barrett, and see what that augurs for the immunity case. She is, of the 3 Trump appointees, the least, the most sort of mysterious, the one who might be least likely to have just rock rib reflexive far right instincts. We'll see if that emerges over the term and over the years. But anyway, you could really sort of do a kind of archaeological sifting through of the data and the metadata here to say that it was this first a dissent, that then Jackson and Kagan, unable to get 5 together, then joined. Wouldn't that be sort of interesting? And it all comes about from a rush to market and a sort of sloppiness about keeping the metadata in. So if nothing else, it makes for quite a lot of interesting speculation. Talk to you later. Hi everyone, Harry here with a really exciting announcement. Talking Feds is bringing our lively discussions with prominent national figures live to San Diego. Talking San Diego is a new series of conversations with some of the country's most interesting and bright minds from the worlds of politics, public policy, law, and more. Our first event is just around the corner. Join me for a conversation with Congressman Jamie Raskin on Monday, March 18th at 2 o'clock in downtown San Diego. You can click the description box below for more information on the event and the series and find out how to purchase tickets, which are going fast. I can't wait to have some of our most well-known friends of the podcast join me in person before a live audience. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.